Secondary basis.
Application first.
Yes.
For applying the list for applications first in connection with motor vehicle.
Application?
First.
Yes.
We mentioned that.
Do we mention of?
For railway accident claim case, Lordship.
Yes, give the slip.
And one hearing.
Hearing of?
Accident, no, railway accident.
Yes, yes. MSCC case? Yes.
My lord, hearing for railway untoward case.
Railway claim case? Yes.
One the application, but was disposed of by your lordship coordinate train, thereby dismissing the appeal of.
No, the appeal is disposed.
Dismissed
Yes.
by your lordship coordinate train,
Yes.
directing the registry to pay me the entire sum which is deposited before the registry.
Yes.
Due to the spelling mistakes in the cause title of the appeal.
Okay, to be mentioned.
Yes, I filed an application. for that.
Application you have filed. So let it appear under the heading application.
As your lordship.
Yes.
Claim case, application and hearing process.
Under of which case?
Claim case.
Yes. MSCC case. Please.
My lord, may I have your lordship's kind leave to mention, my lord, Mr. Chatterjee, my lord, is leading me. He's appearing
My
online.
lord, may I most humbly, my lord, pray that this matter may kindly be listed, my lord, as to be mentioned, because there is an order of stay, my lord. The parties have settled the matter, but they can't, my lord, move it before the trial court because there is an order of stay, my lord, from this honorable court. Kindly keeps it as to be mentioned, my lord, to vacate the interim order so that, my lord, we can know.
Wait the other side.
Yes, yes, we'll give notice.
Yes.
Grateful, my
So
lord.
grateful, my lord. So grateful.
Tomorrow, my lord.
An application. Just. Yes, inclusion for?
In the list hearing
In connection with second appeal. Yes.
Second appeal. So second appeal mentioned next week.
No, an injunction application
Yes.
pertaining to second appeal. For the hearing of the injunction application. The second appeal was admitted by the Honorable Division Bench of
Yes.
City Court, sir. Then
No, it is to be heard by the single bench. So regarding second appeal, I am permitting you to mention next week. So this week I am confining only to MSCC cases. Mention next week any second appeal matters.
My lord, this is a matter to restoration of a second appeal, my lord.
Anyway, mention next week. All second appeals mention next week.
May I come to mention? I am mentioning for a matter of a bill matter. Your lordship heard this matter in vacation bill.
No, matter?
Of bill matter.
Yes.
Your lordship heard it in vacation bill.
Yes.
What happened in the order? There is written as a fake currency. Matter. It is a case of 302. Some currency has been recovered. No fake currency. So, my lord, I am praying for to be mentioned for correction, my lord.
Correction regarding what? Regarding
the word, my lord. Kindly see the order, my lord. It is written as a fake currency, but it is a currency recovered from the accused person, not fake currency. I am for this state. Next.
Okay, to be mentioned.
My lord, I have served on other side, my lord.
Madam, modest claim case applications.
Application for?
Modest claim case.
Yes.
My lord, I am like to mention matter to be mentioned for correction and applications for inclusion in the list, my lord.
Application for?
claim case
Claim
case.
Petitioner,
yes.
petitioner, my lord. Sorry, my lord.
May I have my lord's kind leave to mention 3 applications for inclusion in the list claim case, stay application
Yes.
first time, and 1 for non-prosecution and 1 for hearing, all claim cases. Grateful, my lord.
That's may I have leave to mention the claim case or in listing your lordship list.
Yes.
So these are the claim cases.
Yes, give it.
May I have your lordship leave to mention, Lord, on original side matter? Lord, officers are here, Lord. I have given no.
Anyway, original side, is it a part-heard matter?
Part matter. Lord, it is in regard to the Lord Rajkumar Agarwal versus RC State, Lord. Your lordship appoint commissioner to take evidence in the matter, Lord.
No, is it a part-heard
Yes,
matter?
part-heard.
No, how have I recorded that? Any part-heard matter? So Anyway, you see, because the part hard means it was as the deposition stage. It's not that arguments were hard. So although it is a part hard matter, it has to be released because
it has been hard by your lordships.
no, it has not crossed the evidence stage. Had it been at the argument stage and made part hard, very well, I could have considered. But it has not crossed this evidence. Anyway, as it is appearing as part hard, I'll let it appear tomorrow. I'll release it. Yes, to be mentioned tomorrow.
Appellate side. Item number 1. I am for the respondent, my lord. One can application has been filed because the matter got dismissed on 6 December 2024 and within
This is CAN 5. So CAN 5 is an application for restoration.
Restoration of the order power.
Okay, where is? Let me see. When was the order passed?
Order passed on 6 December 2024.
Just a minute.
6 December. On 3rd January.
CAN 5 টা দিন একটু আছে এর মধ্যে উপরে এটা ও ঠিক আছে
CAN 5
6/12/2024
3rd January it has been filed. The restoration application filed.
Yes, you are for the opposite party.
I am for the claimant, opposite party.
You are for the claimant. You are for
I am for the appellant. He is the
appellant.
Everything is ready, paperwork is ready.
Okay, you are for the opposite. No, you are for the appellant.
I am for the appellant.
Appellant Union of India,
Yes,
Eastern Railway.
Eastern Railway.
Yes, record an order.
Kindly, my paperwork already filed.
Okay, learned advocates for the parties are present. By consent of the learned advocates, application CAN 5 of 2025, which is filed for recalling of order dated 6/12/2024 is taken up for consideration. Stop. By order dated 6/12/2024, this appeal was dismissed for default for non-appearance of the appellant. Stop. The appellant petitioner has shown sufficient cause for being not present on the date fixed. Thus, the order dated 6/12/2024 stands recalled and FMA 2786 of 2016 stands restored to its file, original file and number. Let this matter, as the paper books are already filed.
Already ready when and filed also.
Let this appeal appear for hearing on 18/11/2025.
And my lord, 2 p.m. my lord, he is busy council.
18/11/2025
at 2 p.m. my lord.
at 2 p.m.
My lord, did it be 21st Friday? কবে? শুক্রবার।
21st, you see, Friday, some part hard matters are to be kept.
ছেড়ে দাও না, তুমি কত তারিখে বলেছি? On 20.
I can keep it on 19 if you want.
Then already 18 my lord.
Okay, 18/11/2025 at 2 p.m.
2 p.m. 18 December. 18.
Yes, CAN 5 of 2025 stands disposed.
I'm obliged. Get to work.
Yes, other applications are disposed or are pending.
All are disposed. No. Even it is a transfer. No. Transfer. One application is pending most probably. I know.
No, which applications are disposed?
So disposable.
Anyway, let it remain. I shall see on the next day.
As per instruction, all other can from disposed. It is a transfer brief.
না এটা হচ্ছে অপোজিশন রিপ্লাই সেটা মনে হয় পেন্ডিং অ্যাপ্লাই আছে
দেখবো তো ওটা তো এখন ইয়ে নেই মেন অ্যাপ্লিকেশন
Well, these appeal
দেখো তুই দিকে চলে তুই দিকে
Yes, this appeal is ready for hearing.
yes, my lord, I'm filing, my lord, the paper book has been served up to my learned friend. My lord, this appeal is for the enhancement of the award passed by the tribunal. My lord, the tribunal assessed 6,500 to a dead person who had a business and also, my lord, has the income tax return.
So this appeal, paper books are ready. This appeal has to be heard out.
I'm filing, my lord.
So let it appear for hearing next week.
Next week.
Yes, record an order.
Your Lordship has kept note a lot of matters, my lord, of ours, my lord. We'll make it in the first week of December, my lord.
First week.
Yes.
Well, it's a short matter, only on the basis of
But all
ITR.
matters are short, my lord. All matters are short. All are death cases. And every matter.
My lord, every matter has an urgency, my lord.
Okay, learned advocates for the parties are present. Let the paper books file be kept with the record. Let this matter appear on 1/12/2025 for hearing
Grateful to my
at the top of the list.
my lord.
All my lord, তুই ভয় পেয়ে গেলি তুই?
তোমাকে ভয় পাবো না তুমি আইন ছাড়া সব বলো
আচ্ছা এটা হয়ে গেছে ও এটা একটা 10-এ আছে জলপাইগুড়ি ম্যাটার এটা কি ঠিক হলো
দিয়ে দেন
Number 3.
and I'm for the appeal petition my lord. This is my stay application my lord. My lord, there is scanned one my lord. My lord, I have deposited the statutory amount of 25,000 my lord. Okay, my lord, it is appearing as to be mentioned. Let it appear on Monday. Let this matter appear on 10/11/2025 under the heading application. Intimate the other side. No, my lord, this first time appearing, my lord. Okay. 10/11/2025. My lord, after your lordship's direction, I shall serve, my lord. Record here. No, just under the heading claim case. To be mentioned, na claim case হিসেবে.
My lord, with regard to item number 2, my lord, leave be granted to file the paper book. Paper book I am ready and copy be served. Kindly take this, my lord, paper book. A paper book.
Item 2 এ কি order লিখলাম?
দেখো তো। না চুপ কর না। দেখি না 2 নম্বরটা।
Yes, I've recorded that. Let paper books be filed and kept with the record. Yes, file the paper books. Yes, I've recorded that.
Number 4.
My lord, kindly, my lord, check মানে কোনটার পেপার বুক ফাইল করছি দেখি ওটা দেখি ওইটা পেপার বুকটা দেখি মানে কাইন্ডলি
Number 5.
item 4
হ্যাঁ
এটা দাও
এইটা না এই যে এইটা না
my lord.
This is also, my lord, the same prayer, but the
Can one is to be disposed of.
Lordship, my lord, pursuant to the interim order passed by this honorable court, my lord, I have secured the entire audit sum. Your lordship will kindly make this stay absolute.
Can 1 2 তো appear করছে না can
My lord, can 2 was condonation disposed of. Can 1 is stay. My lord, may I just my lord, hand over the deposit slip to your lordship, my lord, for
Yes,
my lord's
yes.
convenience.
my
Yes,
lord,
record an order.
my lord, I am appearing for the respondent. My lord,
Learned advocates for the parties are present as the appellant insurance company has deposited the awarded sum in terms of order dated 20th of August 2025.
Lordship.
The judgment and order dated 16th August 2024, passed by learned Additional District Judge, Third Court, Paschim Mednipur, in MSCC case number 451 of 2018 shall remain stayed till the disposal of the appeal. Let paper books are ready.
No, my lord. Milord, it would, Milord, हो गया আছে?
As the paper books are ready, let it be filed and kept with the record. Copy be served upon learned advocates.
Already served.
For the other side, if not already served, let this matter
Yes,
appear
No,
for hearing. Yes, when
Milord, I take his word, Milord. It is not with me. He will give it to me.
No, my lord, I am giving the receipt.
আরে ছোড়ো এটা জটাই নেই জজ সাহেবকে কেন
I've
বিরক্ত
recorded,
করো?
let it be served, if not already
Yes.
served.
সবকটা জিনিস বিরক্ত করো কেন? আমি তো বলছি দিয়ে দেবে।
Let this matter appear on 1/12,
জজ সাহেব
1/12/2025.
Milord, on second, if my lord is kind enough, Milord.
I'm keeping it on the same day, the other matter with Mr. Bonik. Okay, 1/12/2025. Within first 5 matters.
Yes.
Lordship.
Number 5.
But I'm for the appellant and petitioner.
I am appearing on the respondent claimants, my lord.
This is application for stay. First time appearing, my lord. I have deposited the statutory amount of rupees 25,000, my lord. That. And my lord, may I, my lord, submit, my lord, the usual stay order, my lord, granted by the coordinate bench, my lord. Yes, record an order. Learned advocate for the parties are present, as the appellant has deposited the awarded sum.
No, my lord.
No,
Statutory
statutory
amount
amount.
deposited.
Okay, as the appellant
This first
has
time
deposited the statutory sum,
25.
the order dated, the judgment and order dated 16/6/2025, passed by learned Judge Special Court, Durgapur, in MSC case number 33 of 2020 shall remain stayed
For a limited
for a
period.
period of 6 weeks. The appellant is further directed to take steps to deposit the awarded sum on or before 2/12/2025. 2/12/2025.
Well, kindly grant 4 weeks time.
No, you are getting 4 weeks. This is okay. 8/12/2025. Let this matter appear on
Along with
along with interest
at the rate of 6%.
No, whatever is there, along with interest, whatever is there, as per the trial court's order. By 8/12/2025, let this matter appear on 9/12/2025.
My lord, if my lord, the appellant deposit the entire awarded sum together with interest within the stipulated time.
No,
then
it will appear. I've already granted 6 weeks time.
I shall prepare the paper book, my lord.
No, I've already stayed it for a period of 6 weeks. Okay. The matter will appear 6 weeks. Probably it will be 22nd December or something. So the matter will appear on 8/12/2025. 9/12/2000.
Yes, 9/12/2000.
By this time you deposit. I've already stayed it for 6 weeks.
And my lord, I shall prepare the paper book.
Okay, on the next day.
আমার নাম রেকর্ডে আছে ওটা নিয়ে যাও
দিয়ে দিয়েছি
দিয়ে দেন
দিয়ে দিয়েছি
কোনটা? Item 6.
6 and 7. Mr.
Okay, when it is due to appear.
My lord, in this matter, I
don't know when it is due to. Is it? Item 6 is due to appear today.
My lord, in this case, my lord, Mr. Pahar is appearing. He has been suffering by because.
Okay, I'm making it not today. Not
My
this
lord,
week.
my lord,
Okay, not this week.
kindly me permit to submit.
No, other side is not present. How can you submit, you see?
The earlier bench has fixed this matter on 26/11/2025.
Oh, it is already
25.
there.
Already by the earlier bench.
So it is appearing by mistake. Yes. Let this matter appear on 26/11/2025. 25/11/2025 as earlier directed.
Much.
Number 8.
I'm appearing on behalf of the appellant insurance company.
Any applications are there now?
No.
It
is a-
on Monday, your lordship desire to hear.
May I submit, my lord? This is my appeal. He may kindly take his seat.
Yes.
I have preferred this appeal, my lord. Paper books are already there before my lord. I have taken the ground, my lord. It's mainly on the ground of quantum. A minor child.
United India? Okay, United.
Yes, I'm appearing on behalf of United India. A minor, aged about 12 years, my lord. She passed away. And her parents, they filed the claim application. The learned tribunal took the income of the minor at 5,000 rupees per month. So I have disputed this assessment of 5,000 income per month of a minor. My contention is that it should be notional income. I'll give certain judgments, my lord, of the
What was
Supreme
the
Court.
age of that person?
12 years.
12 years.
The minor was aged about 12 years. Her parents, they filed the claim application. So this is my first ground. And thereafter, I have also taken the ground that the general damages, my lord, a total of rupees 1,10,000 was granted. That should reduce. It should be 30,000. So these are my mainly two grounds, my lord. My lord will at the very first go come to the claim application, my lord. Wherefrom my lord will find that the victim was aged about 12 years. Page 1 of the paper book, my lord.
Yes, give the paper book.
Yeah. My lord, then me? My lord will take my copy.
No, have you filed the paper book?
He has filed the copy.
Yes. Paper book
Paper
to think.
book.
No, this is supplementary paper book, original.
This is informal paper book, my lord.
No, it is written here supplementary paper book.
Oh,
আর আছে নাকি?
supplementary niche lekha ache. No, but this is maybe it's a typographical error, but this is the paper book.
Yes.
My lord will see at page 1, my lord. Victim was a student of 12 years. That is what they have stated, student. And the income, my lord, as per notional income. Now, regarding the student, there is no evidence, my lord, that the victim was a student because none of the school certificates were exhibited.
See, all persons are students at this stage. You will hardly find illiterate persons of
Yes.
12 years or something.
No. We do find, my lord.
Very rare. Most of the persons are students.
This is an
Which area?
My lord.
Which area? Which locality?
That is exactly, yes. I was just, it's Bankura. So chances are there that maybe
It's hardly
considering
you will file at this age, there is child labor on who are not students.
we do not know, my lord, because there is no evidence.
You should have ascertained that.
May I continue, my lord? It's only on the basis of oral submission, my lord, that the mother has come up in evidence.
Now question is regarding you have challenged the quantum, not
My lord. The mother has come up in while giving evidence. It's at page 8. My lord will kindly see page 8. Page 8. My lord says the mother says that the victim was a student.
Okay.
And the cross examination is at page 11. The cross examination starts at page 11, my lord, and wherein I do not find any line regarding the. I cannot, just one line, my lord will kindly say, I cannot tell the exact date of the alleged accident as I am illiterate lady, the mother says. So considering the financial status of the victims, my lord, whether the victim was at all a student or not, it's in question. That is one ground. Anyway,
You see,
be that
free education.
My lord,
In village there is free education.
should be.
So
should
why
be,
this?
should be. All on assumption, my lord. Anyway, even if that is there,
Okay, now that is accepted.
that is accepted, and the income, it has to be notional. That is one ground. And as far as the general damages are concerned, my lord, it's a total of 1,10,000 has been
considered. Let us see
the judgment, my lord.
Yes.
It starts at page 14, my lord. It starts at page 14, and the relevant. My lord, may I kindly ask him to keep quiet, my lord? It's very disturbing. Page 14, the award starts, my lord.
Okay.
আচ্ছা আপনি বলুন আমি বসি
Yes,
It's very
please.
disturbing, my lord. I do not understand what is his difficulty.
Please allow her to submit.
He'll continue doing this in every court. Every court scolds him, and he just goes on and on. My lord, the regarding the income, my lord, it's at page. The quantification, it's at page 39, my lord, wherein that
Page 39.
starts at page 39, last paragraph, the quantification. And the income, my lord, it has been dealt with at page 34, second paragraph.
Yes.
Second, considering the facts and the circumstances, I am of the considered view that if rupees 5,000 per month is reckoned as the notional monthly income of the victim on the date of his death, as the same is settled proposition of law where the Honorable Apex Court at times on innumerable occasions has been pleased to conclude that absence of evidence regarding monthly income of the victim, the tribunal should consider the notional income of a person, that too on days when the judgment was delivered at the rate rupees 100 per day or as rupees 3,000 per month. My lord is aware of that judgment, my lord, Lakshmi Devi. So the day-to-day expenses, cost of living have enhanced, and I do not find anything unusual in holding notional income of rupees 5 lakh per month for the victim. I'm sorry. 5,000 per month for the victim who had not been in permanent job, or in other words, annual income of 60,000. Thereafter, my lord, the quantification is at page 39, last paragraph. And continues at page 40, my lord. My lord will see.
So here is the annual income is considered on the basis of 5,000.
5,000. This is where this is
personal expenses, that is there.
That is there. Half has been deducted. Multiplier of 18 has been assessed. Now I'll straightway come to two judgments, my lord, without wasting much of my lord's time.
Yes.
My lord will kindly come to my lord. Kishan Gopal, my learned friend, is aware of this judgment. Kishan Gopal, my lord.
What was the age of this victim?
In this judgment, my lord?
No.
12 years. 12 years.
12 years.
Yes. In the instant case, it was 12 years.
Yes.
Herein, my lord, a total at this page 245, the next page, second page, my lord, head note, the paragraph B, my lord.
Yes.
Motor Vehicles Act 1988, section 166, 168, death of children in motor accidents between age group of 10 to 15 years. Compensation for non-earning members, amount fixed for notional income under Schedule 2 at rupees 15,000 in the year 1994 in respect of the dash enhanced notional income than fixed in Schedule 2, having regard to decreased value of rupees since 1994 as the deceased was 10 years old, assisting parents in their agricultural occupation it is just and reasonable to take his notional income at rupees 30,000 per annum. And this observation, my lord will kindly see, this has been followed in a number of subsequent judgments. I'm giving that. In this case, the victim was assisting the parents in the agricultural work, and in my case, instant case, victim was a student.
This is only one child, or
In
that
this,
is there any other evidence that this?
in my case,
Yes, one child or other child.
I am not sure. I'm not.
No evidence.
There is no evidence.
Yes, so this is one judgment. The next.
I'll just check if there is any other child. My lord will kindly grant me a moment. Yes, there is a son. Naki ke mara galo, Akash Baske. No. I'm sorry. Akash Baske died.
So this
There is no evidence. There is no
This
evidence.
is the daughter.
Son died. Son
Yeah,
died.
you see in the evidence.
There is a son and the daughter died.
Oh, right.
Yes. There's a son and the daughter died. So, my lord, in this judgment, my lord will kindly come to, in the one I gave, Kishan Gopal. Page 256, my lord will see, paragraph 35.
Page 256.
Now, Kishan Gopal has considered the judgment of Lata Vadva. That's an on the basis of that and a number of other judgments, my lord. Paragraph 35, the relevant portion of clause 6 states as under notional income that 15,000 per annum. The aforesaid clause of the second schedule to section 163A of the Motor Vehicle Act is considered by this court in Lata Vadva versus State of Bihar while examining the tortious liability of the tortfeasor, has examined the criteria for awarding compensation for the death of children in accidents between the age group of 10 to 15 years and held in the above case that the compensation shall be awarded by taking the contribution of the children to the family at rupees 12,000 per annum, and multiplier 11 has been applied taking the age of the father, and then under the conventional heads the compensation of 25,000 awarded. Thus, a total sum of rupees 1,57,000 was awarded in that case. After noting the submissions made on behalf of TISCO in Lata Vadva case, that the compensation determined for the children of all age groups could be double, as in its view the determination made was grossly inadequate, and the observation was further made that loss of children is irrecoverable and no amount of money could compensate the parents. Having regard to the environment from which the children referred to in that case were brought up, their parents being reasonably well placed officials of TISCO, it was directed that the compensation amount for the children between the age group of 5 to 10 years should be 3 times. In other words, it should be rupees 1.5 lakhs, to which under the conventional heads a sum of rupees 50,000 should be added, and thus the total amount in each case would be rupees 2 lakhs. Further, in Lata Vadva case, it was observed that insofar as the children of age group between 10 to 15 years are concerned, they are all students of class 6 to 10 and are children of employees of TISCO, and one of the children was employed in the company. In the said case, having regard to the fact the contribution the deceased child was taken rupees 12,000 per annum appears to be on the lower side, and held that the contribution of such children should be rupees 24,000 per annum. In our considered view, the aforesaid principle laid down in Lata Vadva case with all force is applicable to the facts and circumstances of the case in hand, having regard to the fact that the deceased was 10 years old, who was assisting the appellants in their agricultural occupation, which is an undisputed fact. We have also considered the fact that the rupee value has come down drastically from the year 1994, when the notional income of the non-earning member prior to the date of accident was fixed at rupees 15,000. Further, the deceased boy, had he been alive, would have certainly contributed substantially to the family of the appellants by working hard. In view of the aforesaid reasons, it would be just and reasonable for us to take his notional income at rupees 30,000, and further taking the young age of the parents, namely the mother, who was about 36 years old at the time of accident, by applying the legal principles laid down in Sarla Verma, the multiplier of 15 can be applied to the multiplicand. Thus, 30,000 into 15, then and rupees that calculation is given under conventional heads towards loss of love and affection, funeral, last rites, etc., which is referred to in Lata Vadva case. And the said amount under the conventional heads is awarded even in relation to the death of the children between 10 to 15 years. In this case also, we award 50,000. Thus, my lord will kindly now come to paragraph 41.2. The awarded amount of rupees 5 lakh with interest at so the amount, principal amount was fixed at rupees 5 lakh. In this case, in my case, the tribunal had granted rupees 8,66,000. That is the principal amount. This is one case, my lord. Now, this was Kishan Gopal. Yeah. Now, my lord, there is another one wherein Kishan Gopal was considered. This is Meena Devi, my lord. My learned friend is well aware of this judgment also. Meena Devi, my lord, will kindly see. Herein also, the principles laid down in Kishan Gopal was taken into consideration, and the amount of compensation, the principal compensation, my lord, it was fixed at rupees 5 lakh. And in this case, my lord, this 30,000 income per annum, it was inclusive of the future prospect. The relevant portion, my lord will find at page number, the last but one page, paragraph 13, my lord.
Yes.
Thereafter, in Kishan Gopal, a child aged about 10 years died in a road accident, which took place on 19/7/1992. This court made departure from the second schedule of the Motor Vehicle Act and accepted the notional income of rupees 30,000 in place of 15,000, applying the analogy that the value of rupee has come down. Thereafter, after 2-3 lines, my lord will see, however, accepting the notional income as rupees 30,000 and as per the age of the parents, the loss of dependency was that Kishan Gopal portion that was thereafter another judgment has been dealt with, and thereafter, my lord, the very next page, my lord will kindly see paragraph 16, the next page, my lord. Thus, has my lord found it?
Yes.
Thus, applying the ratio of the said judgments, looking to the age of the child in the present case, that is 12 years, the principle laid down in Kishan Gopal are aptly applicable to the facts of the present case. As per the ocular statement of the mother of the deceased, it is clear that the deceased was a brilliant student and studying in a private school. Thereafter, accepting the notional earning rupees 30,000 including future prospect and applying the multiplier of 15 in view of the decision of this court in Sarla Verma, the loss of dependency comes to such and such. And thereafter, my lord will kindly see the last paragraph. Accordingly, this appeal is allowed. The amount of compensation as awarded by the High Court is enhanced by rupees 3 lakh in addition. Initially, 2 lakhs was granted. Thereafter, it was enhanced by rupees 3 lakh. And finally, rupees 5 lakh was granted. And herein, my lord will see at paragraph 16, my lord, 6th or 7th line, my lord, therefore accepting the notional earning rupees 30,000 including future prospect. And that too in a case wherein the victim was a brilliant student, that has come up in evidence. So in my case, it should be less than that. This is one judgment, my lord, and the last of the last coordinate bench, my lord, these judgments were followed. My lord, Honorable Justice Ananya Bandopadhyay, my lord, my lady had disposed of this appeal, my lord, wherein wherein, my lord, at page 3, my lord will find a total of 5 lakh, my lord, was granted for the death of a child. In that case, the victim was a 12-year-old child. That, my lord, will find at page 2, first paragraph. I'm sorry, that is the judgment, and in that case, the victim was aged about, yes, victim was aged 12 years. So these are my judgments, my lord.
So what were the decisions which was considered by the learned trial court in arriving at the findings?
Nothing, I do not find Pranay Sethi, Sarla Verma, usual decisions, but as far as the income of the victim is concerned, my lord, I do not find, I'll just recheck.
So this is Lakshmi Devi. This is what is found in the order.
Lakshmi Devi. But that is not applicable in my case. With page 33 is there, my lord, page 33 and 34, wherein the income has been, issue of income has been dealt with in the award, in the paper book at page 33, my lord. There's, except Lakshmi Devi, I do not find any other judgment, and then Pranay Sethi and all those are there. But this is the observation of Honorable Supreme Court, my lord, that in a case of death case for a child, maximum A sum of rupees 30,000 can be granted, which is inclusive of the future prospect. And those cases, my lord, I again reiterate, my lord, the children, they were brilliant students, and that has come up in evidence. In my case, not there is no evidence even regarding the but we can assume that the victim was studying. This is my case.
Maximum amount which could have been awarded is 5 lakh.
Yes, total of 5 lakh. Though initially, the honorable
any other authorities where more than 5 lakh was awarded after this decision?
There may be a few. There
prior to this decision, maybe.
Maybe even after this also there may be, but in injury cases maybe there wherein the
no. This is these type of cases.
সেটা তো ইনজুরিতে last কোর্টে তো
This death of these children.
I must be candid before my lord. In some cases, minimum wages has been considered, my lord, but
no, you see, if it is the law of the land that maximum 5 lakh can be granted, not beyond that,
the view of
then the courts are powerless to grant more than 5 lakh. But if it is left to the discretion of the court,
I understand.
then court can consider what is just and reasonable.
I appreciate, my lord. The honorable.
But I ask you whether there are any other authorities.
There may be some, my lord. In some cases, minimum wages has been applied. I must be candid, but as far as the child's death is concerned,
yes, his only child.
Yes, minimum wages has been taken into consideration of the child. That is also there. But Honorable Justice Ananya Bandyopadhyay, when she was taking up these matters, my lord, in one of my cases also, I must be candid, minimum wages has been applied. But in that case, my lord, victim was alive because it was an injury case.
Oh, that
yes,
is different. You see,
it's not death case.
Injury is one thing to a parent, and death is one thing to a parent.
Yes.
Injury,
yes, my
children
lord.
is there.
I'm grateful.
Cannot be equated.
Yes, my lord. And Honorable Supreme Court's view is, my lord, this 163 amendment, my lord, in the amendment, 5 lakh has been granted total for death cases. So the compensation should not be less than that. That is why 5 lakh was fixed, if I am not wrong. Thank you.
That's all.
That's all.
Yes.
This is the fatal death claim case under section 166 of the Motor Vehicle Act, where the victim disease was the girl of the the respondent claimants, who was daughter of the respondent claimants, died in the year 2021. That is, the accident took, kindly noted, accident took place on 22nd November 2021. The offending vehicle is a truck. Crash and negligence has been proved under the 166 proceedings because there are the two oral evidences. One is eyewitnesses and one is PW1 is the claimant, Kalpana Baske, who is the mother of the DP. The documents which are produced by my clients, the FIR, the written complaint, seizure list, and PM report, insurance policy, and Aadhaar card of the disease, and the Aadhaar card of the the respondent claimants. All are exhibited from 1 to 11. Now, the grounds, the learned tribunal, after considering the both oral and documentary evidence, considers, that the claimants are entitled to get rupees 8,66,000. On the what basis, 5,000 income per month into plus 40 into 12 plus 40% future prospect. It comes 84,000. That was calculated under the calculation portion. 84,000. This since the victim daughter was a the bachelor, so as per the pronunciation or other judgment, that on the heads of personal living expenses, 50%, that is half of the loss of earning, should be made. That is that the tribunal applied the multiplier, and venal damages, the tribunal granted 1,10,000, funeral expenses 15,000, and loss of love and affection 15,000, and loss of parental consortium 40,000 into 2, because there are the parents are 2. Here the respondent claimants are the mother and father. Parental consortium 40,000 into 2, 80,000. So total it comes 8,66,000. Yes, that was challenged, by the United India Insurance Company on 2 counts. First,
No, the income aspect.
Income aspect. Income, according to my learned friends, income should not be more than 30,000. Is a minor, my lord, as per the Kishan Gopal and the
Meena Devi.
Meena Devi.
And also, my lord, the Manwara Bibi, as my lord.
This is a Manwara Bibi is an injury case.
No, it's a death case.
Death case.
Manwara Bibi as held by Her Lordship, the Honorable Justice Ananna Bandyopadhyay. Now, my lord, I will distinguish, my lord, 3 judgments. And I will place, my lord, the judgments, very recent judgments of the Honorable Apex Court, where this, my lord, was aged about 12 years, considering the inflation of money and devolution of, my lord, the aspects, my lord, and also the tribunal, my lord, consider that taking the, my lord, if your lordship kindly turn to page 33. My lord, page 33 of my paper book. May I permit it to, my lord?
Yes.
In the present case, considering the fact that the disease was only 12 years of age, a student at the time of her
Page
death,
33 of your paper book.
page 34.
Page 34, yes.
And the judgment page 21. 12 years of age, a student at the time of her death, we can well lead our presumption to consider that if she would have lived and natural expectancy of her life, then she would have grown up to become earning member of her family, who have contributed to the family's income and would have carried out responsibility of her dependent parents. In all likelihood, the victim would have either a self-employed or a salaried person. Considering the facts and circumstances, I am the considered view that if rupees 5,000 per month is reckoned as notionally income at the time of the victim on the date of his death, as the same is settled position of law, where the Honorable Apex Court at the time of innumerable occasions have been pleased to conclude that absence of evidence regarding the monthly income of the victim, the tribunal should consider the notional income of a person, that too on the day when the judgment was delivered at the rate of rupees 100 rupees per day, that is rupees 3,000 per month. That is Lakshmi Devi and others. My lord, I pause here. My lord, in Lakshmi Devi versus Muhammad Tabbar, where the accident took place in year 2000, my lord, 4, and the case was decided in the year 2008. My lord, the Honorable Apex Court considered a day laborer who has no skill, laborer who has no, my lord, the knowledge about the, my lord, the performance of the special work. A laborer, my lord, can easily earn rupees 100 per day, that is 3,000 per month. That in the year 2004, and the judgment delivered in 2008, Lakshmi Devi versus Tappar. Now, my lord, my learned friend realized the first decisions, Kishan Gopal, which was distinguished. If your lordship sees the Kishan Gopal, my lord, I am placing, my lord, the
Kishan Gopal is there, yes.
yes, Kishan Gopal is there, where the accident took place in the year 1992. If your lordship kindly see. Page 4, my lord, of my compilation of the judgment.
Yes.
Page 5. My lord, page 5 of my compilation of judgment, page 5. The appellants are the parents of the deceased Tikaram, who died in a road accident.
No,
on
page 4.
9/7,
Page 4.
Page 5. Kishan Gopal versus Lala.
Yes. So this is a 2013.
Yes, they decided. But my lord, the paragraph 2 says the appellants are the parents of the deceased Tikaram, who died in a road accident on 9/7/1992. Why I am drawing your lordship attention that Kishan Gopal's case, my lord, where the accident took place 1992. Now, my lord, in our case, my lord, the accident took place, my lord, in the year 2021. My lord, kindly difference 21 years and 7 years. That is 28 years. After that, your lordship is deciding that what is the, my lord, the reasonable and acceptable income, rational income of a minor student. That's the, my lord, the tribunal says, even if 2004, a, my lord, in Lakshmi Devi versus Muhammad Tabbur, a day laborer can easily earn rupees 100. Now, my lord, if it is, my lord, in 2004, 100, my lord, the 3,000, 5,000 is not, my lord, is unnational and, my lord,
What
unacceptable.
is the latest decision?
Latest decision.
No, this is 2013 you are relying upon.
No.
No, this judgment, that
This
is
judgment, my lord,
Kishan, no, this is Kishan Gopal is 2000.
Kishan Gopal, my lord, I have
Okay.
in my compilation I have given
No, what
because first judgment is, my lord, I am relying that was decided, my lord, in the, my lord, in August 2025. Your lordship, which was reported in 2025, volume 3, TAC 723, Supreme Court.
Yes.
That is Thangaval and others versus Managing Director, Tamil Nadu State Transport Corporation and
Yes.
others. Page 1 to 3. This is the, my lord, the latest judgment. Kindly turn to page 1 to 3. Now, paragraph 5.
Yes. Paragraph 5. Yes, that is there.
Yes. My lord, here paragraph 3 starts, the tribunal awarded an amount of rupees 8,55,000. Our case was granted 8,66,000. Reckoning the income of a child of rupees. My lord, paragraph 3 of, my lord, the paragraph 3, my page 2. This tribunal awarded an amount of rupees 8,55,000, reckoning the income of a child at rupees 5,000 per month and determining the compensation for loss of dependency, adopting the multiplier 18 and deducting 2/3 of personal expenses. An amount of rupees 1 lakh was granted for loss of affection along with funeral expenses 25,000 plus rupees 5,000 each transport and loss of this. This High Court reduced the income of 2,70,000. But the Supreme Court says, my lord, paragraph 5, there is no straitjacket formula as to income of the adopted in the case of the children when they suffer injuries or succumbed to death in a motor vehicle accident. In fact, the tribunal has considered a division bench decision which adopted the income of rupees 5,000 per month for a 9 years old. The High Court does not give any reason to deviate from the said monthly income adopted by the division bench, merely adopts the income as per Schedule 2. Schedule 2 is applied in case where the claim is made under section 166. Our case is, my lord, 166, which proceeds on in a no for liability. In the present case, a claim case under section 166 of the Act was preferred, and there was negligence found on the delivery of the offending vehicles. Now, my lord, in these judgments, my lord, the Supreme Court considered the 5,000, my lord, rupees is income per month to a minor, my lord, the child. Now, my lord, Kishan Gopal, my lord, my learned friend realized I also, my lord, compiled with my compilation. And my lord, your lordship kindly turn to, my lord, the judgment number 3. It was also reported very recent judgment. Kumari Lakshmi Varis and Managing Director of Karnataka State Road Transport Corporation decided on 5/3/2025. The Honorable Justice Sanjay Koral and the Honorable Justice Molmohan.
That is page 5.
No, that is page 15 to 20.
Yes. Which is the paragraph you are relying?
Yes. আমি তোমাকে একটা the paragraph page 15 to 20, Malad, where the Honorable Apex Court observe. My lord, I am reading paragraph paragraph 18 of my lord, the case of my lord Kumari Lakshmi Varis, that the victim is a minor girl aged about 12 years old. Accident took place in the year 2013. Apex Court took monthly income of minor girl as rupees 10,000. Now, my lord,
that is which page?
Page, my lord, page 15 to 20, that was paragraph paragraph 18. point number 2 and 3, paragraph 18, manner page 12 of my compilation. The issues, point number 2 is whether the applicants are entitled for compensation. If so, to what amount? And
Page
what,
12 of your compilation.
page 12, paragraph 18.
Yes.
Now, my lord, point numbers 2 and 3. Point number 3 is what is the award, and my lord, point number 2 is point number whether the applicants are entitled for compensation. If so, to what amount? Now, my lord, paragraph 18. Point number 2 and 3 are answered together in favor of the applicants for the following reasons. My lord, this is a case where the claimants, my lord, preferred the civil SLP before the Honorable Apex Court for the enhancement of the award passed by the High Court. Now, my lord, the point numbers 2 and 3 are answered together in favor of the appellants for the following reasons. Tribunal, having answered the continuous issue number 1 against the appellants in his judgment, the same is concurred with by the High Court by assigning erroneous reason, and it is affirmed dismissal of the claim petition of the appellants, holding that the accident did not take place on account of the rash and negligence driving. This is, my lord, I am skipping over. Since we have set aside the findings of the reason recorded by the tribunals and the High Court contention issue number 1 and 2, we have answered the point in favor of the appellants and also compensation in favor of the appellants, as they have lost their affection 10 years old son. For this purpose, it would be necessary for clause number 6, which refers to notional income for compensation to those persons who had no income prior to accident. The relevant portion of clause 6 states as under: notional income for compensation to those who had no income prior to the accident. The aforesaid clause, my next page, page 13. The non-earning person 15,000 per annum. The aforesaid clause of the second schedule to section 163 of the MB Act is considered by this High Court in the Lata Wada's case. That's my learned friend, my lord, also reading. Lata Wada, and Lata Wada is a, my lord, is a fire case, not a motor accident. Lata Wada and others, and state of Bihar. While examining the tortious liability for the tortfeasors, has examined the criteria for awarding compensation for death of a children in accident between age group of 10 to 15 years and held in above cases, that the compensation shall be awarded taking the contribution of the children to the family at rupees 12,000 per annum, and conventional heads, the compensation of rupees 25 was awarded. Thus, a total sum of rupees 1,57,000 was awarded. After noting the submissions made on behalf of the TISCO in the said case, that the compensation determined for the children of all age groups could be doubtful, as in his view the determination made children is irrecoverable and no amount of money could compensate that in that case were brought up. Their parents being reasonably well-placed officials of TISCO, it was directed that the compensation amount for the children between the age group 5 to 10 years should be 3 times. In other words, it should be 1.5 lakhs, to which, under which the conventional head a sum of rupees 2 lakh. Further, in case referred to supra so and so, so and so, so and so, so and so. And I am skipping on. In our considered view, the aforesaid legal principle laid down in Latawada's case with all four is applicable to the facts and circumstances of this case in hand, having regard to the facts that the deceased was 10 years old, who was assisting the appellants in their agricultural occupation, which is an undisputable fact. We have also considered the fact that the rupee value has come down drastically from the year 1994, when the notional income of the non-earning person or accident was fixed as rupees 50. Further, the deceased boy had been alive would have certainly contributed substantially to the family, the appellants by working hand. In view of the aforesaid reasons, it would be just and reasonable for us to take his notional income of rupees 30,000 and further taking the young age of the parents by applying the legal principle. A mother who was about 36 years old at the time of accident, by applying legal principle laid down in the case of Sarahama Delhi transport, the multiplier of 15 can be applied to the multiplicand and rupees 30,000, 54,500, 5,000 under conventional head towards loss of lover and affection, funeral expenses, last rites held in Kerala State Transport or Sushma Thomas, so and so, lot of other scale. Malo, next page, page 14. In this case, we award rupees 15,000 under conventional heads. In our view, for the aforesaid reason, the said amount would be fair, just, and reasonable compensation to be awarded in favor of the appellants. The said amount will carry interest 9% by applying the law laid down in the case of Municipal Council of Delhi versus Associate of Victim of Upper Tragedy, that is so and so, so and so. For the reason, the insurance company has been contesting the claim of the appellants from 1992 to 2013 without setting their legitimate claim for nearly about 21. If the insurance company had awarded, had paid just reasonable compensation to the appellants, the same could have been either useful for kept it in a fixed deposit, then the amount could have been earned 5 times more than what is the awarded today in this appeal. Therefore, regarding 9% interest on the compensation awarded in favor of the appellant is legally justified. Accordingly, we pass the following hour. Now, my lord, in this case, my lord, Kumari Lakshmi Rari, where the accident took place 2013 and the girl was aged about 12 years, income has been assessed 10,000. But in our case, my lord, the tribunal, my lord, assessed, considering the, my lord, evaluations of, my lord, the money and, my lord. Now, next case is Meena Devi. My learned friend also, my relied. Where the 30,000 as Kishan Gopal's case, where the accident took place, my lord, page 21 to 26. Fatal accident, disease was a child of 12 years. He was studying in a fifth year, equivalent to the value of claim, where my lord 30,000 was granted. My lord Kishan Gopal 30,000 was granted where the accident took place in the year 1992. Meena Devi's case where the accident took place, my lord, that is in the year, my lord,
2003.
2003. And my lord, in Lakshmi Devi Tabbar, my lord, the Talent Tribunal considered that in 2004, a person, my lord, a boy, my lord, a girl, who, my lord, if she be alive, should easily earn rupees, my lord, 5,000. My lord, that's why reasonably, my lord, consider that in 2004, where the Honorable Apex Court says a unskilled laborer can easily earn rupees 100 per day.
Regarding in Pranay Shetty, With regard to the observation of this child, what was the observation?
No, in Pranay Shetty, there is no observation.
Child matter is not dealt with in Pranay Shetty.
Pranay Shetty, my lord, deals with 5 points. Multiplier, future prospects, my lord, the deduction on personal expenses, and my lord, the other points is, my lord,
Those consortium and
consortium, general damages. My lord, here my learned friend challenged my lord 2 counts. On the income 5,000, it cannot, it is my lord unacceptable. It should be 30,000. But I am relying the my lord, the
no,
Supreme Court
3,000 means it is 36,000.
36,000. But my learned friend says that in Kishan Gopal, where the accident took place 92, that should be considered. Your Lordship, kindly, my lord, consider, my lord, the accident took place in the year 2021. What is the value of the, my lord, the money? What is the inflation? What is the devolution of, my lord, the considerable price of a, my lord, a thing? 5,000 is reasonable, acceptable, and rational. That's why, my lord, I am relying Thangara, where this is age is about 10 years. Student, considering, my lord, my lord, where the claimants are parents, considering every aspects, my lord, consider Honorable Apex Court is 5,000 per annum. And in Kumari Lakshmi, that the victim aged about 12 years. My case is also the victim girl was aged about 12 years. So in both 10 years and 12 years, the Supreme Court granted 5,000 per month to a minor income, and one is 10,000 rupees per month. Kishan Gopal Meena Devi's case is long ago in 1992 and in 2003. But your Lordship is deciding the case where the accident took place 2021.
Pranay Shetty, there is a ratio decidendi regarding
No. The income of a person, income of a
Sarola Verma, it was there.
No. Sarola Verma, developed in in Pranay Shetty, that was the future prospect. Sarola Verma only confined to the government employees, but in Pranay Shetty, it's not only government employee, also self-employed and fixed wages person, and also consider the future prospects would be, my lord, up to 60 years, not 50 years. That is the difference between Sarola Verma and the Pranay Shetty. And general damage, Sarola Verma not granted. General damage added 70,000. That's 15,000, 15,000, and 40,000. Now, my lord, second aspect is what the grounds taken. The main two grounds are canvassed in this appeal. One is the income. Second is the excessive amount of the general damages. I considered my lord, the general damages, rupees, my lord, 1,10,000. That should not be. But regarding parental consortium and funeral expenses, that should be, my lord, considered.
No, regarding damages, what is the observation of the Supreme Court? General damages in the decisions which you have relied?
Yes, general damages, I'm relying one decisions and also one decision of our High Court. না, এটা দেয়নি, এটা কেন বের করেছিস? কোনটা? এটা দিয়েছে তো, যেটাও পাঠিয়েছে। তুই কি প্রথমটা বের করেছিস নাকি? পূর্বাল আনসারিটা কোথায়? Kindly, my lord, the decision of Kurban Ansari. আমাকে দেখ এটা আছে, হারিয়ে ফেললে হয় কি করে? একটা নিয়ে একটা করেনি কখনো, আমি দেখেছি দুটো আছে এই যে। Your Lordship kindly turn to, this is a case 163A. Though it is a case 166, but while your Lordships, my Lord, I invite your Lordship, my Lord, ratio of the parental consideriums, my Lord, the filium considerium that was considered in Kurban Ansari. Now, my Lord, your Lordship kindly turn to
So regarding PDL consortium, in this case, it was 80,000, and in the present case, how much?
80,000.
80,000.
80,000. But, my Lord, the funeral expenses, my Lord, my clients are expenses, Sadhu Shanti, that is 15,000.
And the court has assessed how much?
15,000.
15,000, okay.
And, my Lord, the loss of estate, that was not granted.
Loss of estate was not granted.
15,000 granted on the heads of loss of love and affection.
15,000.
15,000. That should be loss of estate.
No, that is granted. How much is granted? 15,000?
15,000, 15,000, 80,000 and 1,10,000. If your Lordship kindly turn
So
to
let
the
me
judgment.
consider the judgment.
Judgment, calculation portion. Yes, my Lord.
That is
page 40.
40 of the inner page.
Paper book.
Okay, paper book, yes.
Annual income comes to 5,000 into 12, including future prospect 40%, 84,000.
Yes.
Malar, since the girl was a Malar bachelor, so Malar, as per the pronunciative Sharavarma, Malar on the heads of Malar, the personal expenses 50% should be, that is half, that is 42,000.
Yes.
Multiply 80, 7,56,000.
So multiplicand is, yes.
And my Lord, general damages 1,10,000. That should not be granted.
Yes. General damages was how much?
1,10,000.
And here it is how much? This case? The case which you have relied.
Kurban Ansari, my Lord, the conventional head. Kurban Ansari the koi.
United India Insurance Company.
Yes. Now, Kurban Ansari was Sam Kishore.
Yes. No. This is with regard to United India Insurance Company versus Srimati Kalpana Baske.
Kalpana Baske is my case, our case.
This is yours?
Yes.
Okay.
Here, my Lord, the Kurban Ansari.
Yes.
Kurban Ansari.
Regarding these general damages, where from this amount is arrived at?
My Lord, your Lordship kindly turn to page 41, the calculation of my paper book.
Yes.
Loss of love affection 15,000. It should be, my Lord, loss of estate.
Loss of estate, how much? 15,000?
15,000.
No.
Though
under the category of this table, under the schedule, there is
general damage includes, my Lord. Here, general damage includes loss of estate and, my Lord, the funeral expenses.
Okay, so loss of estate
and parental consortium, that is Kurban Ansari's case. That is
page.
Kurban Ansari, your Lordship is seeing Kurban
Compilation
Ansari.
of your judgments. Which page?
Kurban Ansari, your Lordship kindly turn to Jala চুপ করো না Yes, my lord, your lordship kindly turn to paragraph 16. My lord, the calculation portion is page 4.
No, page 11.
Page 4, Kurban answer, compilation.
Okay, page 4. Yes.
Loss of dependency 3,75,000.
No, page 4 is Kishan Gopal.
My last, my lord, the one judgment Kurban answer I am giving.
So last one.
Kurban answer. My lord, there is one judgment I have annexed. Your lordship sees, your lordship got it. Kurban answer দেখুন একটা
No, in your list it is not there.
single, yes.
Single. Okay, good. Kurban Ansari.
Kurban answer. My lord, it is the death of a my lord, the child, and the claimants are the my lord, the parents. Our case is also the claimants are the parents. Here, my lord, your lordship kindly turn to paragraph 16, page 4.
Yes.
In view of the above, we deem it appropriate to take notional income of the rupees 25,000 accordingly when the notional income is multiplied with the applicable of it. Calculation portion is loss of dependency 3,75,000 and loss of filial consortium rupees 40,000 into 2. Loss of filial consortium, that is the parental consortium. Loss of love and affections of a son towards his parents.
So that the learned trial court has calculated at 80,000.
80,000.
Okay.
And
Thereafter,
denial damages, learned tribunal calculate 1,10,000. It should be, my lord, lesser 16,500 or my lord 18,500. 2 years, 10%, 10%. So, my lord, 18,000, 18,000.
general damages.
That is on the heads of loss of estate and loss of
Parental
funeral expenses. That the my lord, the Punaseti says loss of estate 15,000. 15,000 is, my lord, loss of.
Okay, let me see again. Loss of parental consortium, that comes to 80,000.
80,000. That is 40,000 into 2.
That is rightly calculated.
Rightly calculated.
So far, funeral expense 15,000. That is rightly calculated.
Calculated. But the loss of estate not calculated.
Loss of love and affection, it is 15,000.
15,000. Yes. To that extent, it was, my lord, rightly calculated.
So regarding general damages, this is a new incorporation. This general damages.
General damage 1,10,000.
So this does not find place in any of the decisions.
Yes, my lord. My lord, your lordship, my lord, day before yesterday, your lordship says actually, my lord, I'm saying, my lord, in the Motor Vehicle Act, my lord, we follow some guidelines of the Honorable Apex Court. Or my lord, some statutory provisions of the Motor Vehicle Act. Now, my lord, if your lordship kindly consider, now, my lord, after amendment of Motor Vehicle Act 1988, no fault liability section on 140 chapter has been abolished. Only 163 becomes 164. That is cap 5 lakh. Is a fatal accident, 5 lakh, and in case of disability, 5 lakh into how much he has permanently disabled.
The percentage.
Percentage. And my lord, in case of a death, general damages, that is the 40,000 towards the loss of consortium. Schedule says my lord, 5,000
As because there are two father and mother, that is two.
40,000. Now, my lord, I am relying another judgment of our High Court. এটা কি উল্টো পাল্টা বের করেছিস নাকি তুই? চুপ কর। My lord, it was delivered the Honorable Justice Partho Saruthi Sen. It's unreported. আমি বলছি শ্রীমতী মাধবী দাস ভার্সেস ওরিয়েন্টাল ইন্স্যুরেন্স কোম্পানি।
Yes.
Here, the case is a minor. The appellant is the my lord, the claimant mother, where the monthly income has been assessed, my lord, 5,000 per month. And your lordship kindly turn to page, the paragraph কোনটা দিলাম রে? Now paragraph 21.
Yes.
জানুরামটা নিয়েছিস? My lord, with regard to non-addition of filial consortium under the heading of general damage, in the impugned judgment, it reveals to the court that the concept and scope of filial consortium has been duly considered by the Honorable Supreme Court in the case of Nanuram alias Chauram, where the Honorable Appeals Court held thus: filial consortium is the right of the parents to compensate in the case of accident death of a child. An accident leading to the death of a child, great shock and agony to the parents and family to the disease. The greatest agony for a parent is to lose their child during their lifetime. Children are valued for their love, affection, and companionship and their role in the family unit. Consortium is a special prism reflecting changing norms about the status and worth of the actual relationship. Modern jurisdiction world over have recognized that the value of a child consortium for exceeds the economic value of compensation awarded in the case of a death of a child. Most jurisdictions therefore permits parents to be awarded compensation under the loss of consortium on the death of a child. The amount awarded to the parents is a compensation for loss of the love, affection, care, and compensation of the deceased child. The Motor Vehicle Act is a beneficial legislation aimed at providing relief to the victims or their families in case of genuine claims, in case where a parent has lost their minor child or a unmarried son or daughter. The parents are entitled to be awarded for loss of consortium under the head of filial consortium. My lord, this is my lord observed by Nanuram. Your lordship kindly see the Nanuram's case. That was the my lord reported case, the Honorable Appeals Court says. My lord, this case which I am reading, that the Honorable Justice, my lord Partho Saruthi Sen, has follows the Nanuram's case.
So what was the quantum laid with regard to filial consortium?
40,000 into 2.
So that is
That
later.
is Kurban Ansari granted. Nanuram
It is
granted.
granted, but that is a guideline later.
Guideline. Guideline, my lord, it is a 163 case, but the my lord, the Nanuram is a 166 case. And
Both have, in both the cases, it is 40,000 into
40,000 into 2. My lord, in Magma General Insurance Company versus Naluram, your lordship kindly turn to page 7. That was quoted, my lord, by
Yes,
the
by
Honorable
Justice Chen.
Chen. The right to consortium, my lord,
Yes, consortium is a special prism reflecting.
yes, that was quoted. And my lord, the Honorable Justice Chen was pleased to grant, my lord, the parental consortium 40,000. Here the my lord, respondent claimants are two, my lord, the father and mother. So learned tribunal, my lord, calculated 40,000 into 2, 80,000.
Now, this question is, this 40,000 is let down in 163A case or even 166 also?
No.
40,000? No, 40,000.
My lord, 163A has been abolished. 163A schedule has been abolished.
No.
It was inserted in the substantial section, my lord. That is 160.
Anyway, old cases under 163A, those were pending, that is there.
Yes. That is there. That
Now,
was,
these 40,000 is laid down in which
It is
case?
163.
So 163A was
163 amended in 1994.
163A.
Came into effect in क्या बोल रहा है?
1994.
It came into effect.
No,
in
163A, many cases were filed under 163A in this 2010, 11, 12.
163A
No.
came into effect in 1994.
Motor Vehicle Act
And then it
1988,
was-
my lord, 163 came into, my lord, in Motor Vehicle Act 1988 on 24.
Very well. Thereafter, now we are in 2025.
25.
Yes. So 163A is amended at present.
Abolished.
My lord,
Schedule abolished.
Schedule is abolished.
Schedule abolished, but 163A comes, my lord, become 164.
Yes. So
Latest-
my lord, in earlier, when in 1994, when the Motor Vehicle Act was amended, my lord, for the first time, this 163A came into the effect.
Yes.
My lord, this was a specific chart. It was only for the persons, my lord, of the poor, downtrodden people of society who have got their maximum income up to the range of 40,000. My lord, as I was discussing before your lordship, my lord, on the last day, that you come, your income is less, you don't prove rash and negligent driving, show the, my lord, the accident, your injury or death, take note of the schedule, take compensation, provided insurance coverage is there, you go away. My lord, from 1994, my lord, till 2022, my lord, 1st April 2022, my lord, when the act was again amended, this 163 was given a go by. My lord, the parliament in its wisdom, my lord, decided that no, we will not make the chart of these different income groups. My lord, it is started from the notional income of 15,000, goes up to the maximum of 40,000 limit. It says no, in case of death, all cases, whether it's a child or whether it's, my lord, an octogenarian, we give 5 lakhs. The principle remains same, accident, death, policy coverage.
And that's an negligence man not required to be proved.
That is 164.
That is, my lord, now it has become, since 163 has given a go by, my lord, it has now been turned into 164. So after 1st of April 2022, my lord, the accidents which have, my lord, been taking place, they are, my lord, under the new act. But my
Under
lord,
no fault liability means 5 lakh.
no fault liability means, my lord, 5 lakh. I'm not according, my lord, as far as, my lord, this injury part is concerned, my lord, injury also percentage of injury is to be taken into consideration. Maximum ceiling remains 5 lakh. If you suffer 50%,
kindly see
so, my lord, 50% of 5 lakh, you get, my lord, 2.5 lakhs. It's like that. So, my lord, it has been simplified instead of making, my lord, all those calculations. And as far as, my lord, this 40,000, what, my lord, the specific query was, from where is it coming? 40,000.
40,000.
My lord, that is what not I am answering.
Yes.
My lord, earlier, my lord, there is a one, this in under 163, my lord, there is one category, general damages. My lord, we are borrowing this term general damages from there. General damages, my lord, is consisting of 3 different heads. One heading general damages, consisting of 3 different heads: loss of estate, funeral expenses, loss of consortium. These 3 combined together, for the ease of saying, will not make it convenient to say or to use the term general damages. General damages is of A, B, and C: funeral, consortium, and, my lord, loss of estate. These three combined together becomes general damages. My lord, there was a lot of confusion with regard to these three heads. What to be given what to be given what. Because my lord, here in this 163A, amount is specified. But in 166, amount was not specified. There was a lot of confusion. Different honorable courts, different honorable judges, including Supreme Court, they were giving different amounts, my lord. I had indicated to your lordship, my lord. Sarla Verma confined it, combined of these three different heads under general damages to 20,000 rupees. Supreme Court, my lord, in Pranay Sethi, when 5 judges sat together, they said, okay, no, we will fix it up now. Again, the rule of thumb, my lord, term was used. They say, for 15,000, we will give for funeral, no increase on that. 7 accept that 10% every 3 years. Will it? A is 15,000. B, my lord, this loss of estate, 1.5, again 15,000. And C, a spousal consortium. My lord, consortium was given, it was confined, it was made sure that it is confined to the term spousal consortium. My lord, after
আমি বলছি মানে after Pranay Sethi, there are lot of judgments.
Pranay Sethi does not deal with child.
Does not deal with child.
Anyway, other than that,
So my lord, this spousal consortium it was confined to. So these 15, my lord, this funeral and estate and consortium, 15, 15, 40. These three together, for the ease of saying, my lord, we say general damages, A, B, and C, it became 70,000, 70. Pranay Sethi said that it should not increase the 70,000, these general damages, or these three put together. After every 3 years, you add on 10%.
Loss of consortium.
Loss of consortium.
Loss of consortium, where my lord, the disease.
That is after 3 years, it should increase by
this entire general
10%.
damages head, my lord. This entire general damages head, 15,000, 15,000, 40,000, put together 70,000.
15, 15 and 10.
15, 15 and 40.
40, right.
40 consortium, 15 funeral, 15 loss of estate. So this is 70 together, 70. This 70 would increase every 3 years at the rate of 10%. So in 2017, the judgment was there. It would cover up to the year 2020. So 2020 November onwards, it would be 10% increase becomes 77,000. So this 2020 November, it finishes off in 2023 October. So from 2024 October, if you have not received the money earlier, if the claimant has not received the money earlier, and he is receiving it for the first time, then he will get it 77,000 plus 10%, this is 7,000, 84,000 or a little higher than that, So this is why, 70,000 after
this
3
is
years.
The general damage category.
This is general damage category, consisting of 3 different heads.
Now here you see not a case of spouse. It is a case of child.
The case of
That
child.
spouse consortium will not be applicable.
It will not be made applicable.
Others are there.
Yes.
Pranay Sethi does not deal with the my lord, the
very
child's
well.
death.
That is why
Pranay Sethi specifically has dealt with this consortium point. And it has said consortium would be confined to, your lordship, I had given to your lordship.
What I am.
My lord knows about it,
This Pranay Sethi has not made any observation with regard to that children's
No,
consortium.
no.
Only with regard to spouse.
Whatever
is there, that has to be followed.
Pranay Sethi has dealt with, not with the child. It did not deal with the child. It has dealt with the multiplier aspect. That for this age group, what should be the multiplier? Pranay Sethi has dealt with, this personal deduction aspect, that loss of dependency, how many dependents are there, and for what dependents, what should be the loss of dependency, that has been there. And there, Pranay Sethi has specifically dealt with, this general damages aspect, and said that this general damages, different courts are giving different views. Let me, put together that, yes, what should be this loss of estate, what should be the loss of this funeral expenses, and what should be the consortium? Because Sarla Verma granted 5,000 rupees for this estate, 5,000 rupees for funeral. One other court granted 1 lakh each. Pranay Sethi said, forget about all these. Whatever is coming into your veins, with the greatest of respect and humility, I say, whatever is coming into your veins, let me fix up one specific figure. And Pranay Sethi, therein, 5 judges taking note of all other earlier division benches and 3 judges.
Of a minor
We are not talking about minor. He doesn't even understand what we are submitting, what we are
Whatever
discussing.
Pranay Sethi is there, your learned friend is contending that.
So, at least these 3 aspects were made absolutely clear. That no, this is what we are fixing, and this should be wait, my lord, that is the rule of the law, my lord. 5 judges were set together. So this should be followed by all other subsequent benches. And this is what we are following till date. My lord, I was surprised to note, my lord, I was surprised to, my lord, note that why, my lord, yesterday, my lord, I remember the term I used for my learned friend, my lord, misleading the court. Your lordship will kindly pardon me for that. He has today referred a judgment of Honorable Justice Parthasarathy Sen. Just now, I was sitting here. It referred to one Nanu Ram judgment. In Nanu Ram judgment, my lord, this parental consortium has been added, 40,000, 40,000, 80,000. He forgot to tell it to your lordship. This Nanu Ram judgment, it came after Pranay Sethi. Pranay Sethi said 40,000. Nanu Ram said, okay, I go a step further. A division bench says, I will go a step further over and above 5 judges bench. They are under 142, my lord, Article 142. Supreme Court judges can say, my lord, they can call night a day, day a night. They have got that power. So in Nanu Ram, Supreme Court, my lord, used Article 142, and they said, we will give more and over and above what Pranay Sethi granted in consortium. Pranay Sethi said consortium should be spousal. It said, no, we will give for the parents also. This Nanu Ram was considered by 2 honorable division benches of this honorable court. One division bench headed by Honorable Justice Dipankar Datta, now sitting in Honorable Supreme Court. Another division bench headed by Honorable Justice Sanjeev Banerjee, my lord, the ex-Chief Justice of Meghalaya High Court. Both of them dealt Pranay Sethi with Nanu Ram and said Nanu Ram is bad. Nanu Ram should not go over and above Pranay Sethi, and for that matter, not only Nanu Ram, all other judgments which have tried to, my lord, overgo Pranay Sethi, it was said that no, these are bad judgments, we will not consider, we will follow Pranay Sethi. I was expecting that he will refer those as well. He did not so. Till date, more than 1,000, I say, my lord, with authority, more than 1,000 judgments have been passed by this honorable court, wherein this consortium has been confined to 40,000 only. He is not referring to those, he is bringing out one straight judgment of Honorable Justice Parthasarathy Sen, wherein
do one thing, you bring those judgments tomorrow.
My lord, any single judgment, my lord will put my lord's finger.
Whatever it is,
I'll bring.
You give your reply, show those judgments.
Lordship. I'll bring the division bench judgments.
The division bench judgment which has considered this Nanu Ram.
Lordship. Which has considered this Nanu Ram.
Yes.
Lordship.
My lord,
Yes.
Nanu Ram's case, my lord, has been followed by the Honorable Justice Sen. And also, my lord, I will also, my lord, place, my lord, the Honorable Justice Shobha Dattopal. Her lordship also granted my lord, the filial and consortium to the parents of a child. So what?
My lord, we are here today to assist your lordship.
I'm not asking,
not to burden your lordship.
My lord,
one or two straight judgments.
What be the just compensation? My lord, why the Pranay Sethi does not deal with a minor death,
Okay,
my
now
lord.
we do one thing. So you submit. So your learned friend will reply and bring those 2 division bench judgment. Okay.
Wherein Nanu Ram has been considered.
Okay. You also bring anything else tomorrow? So have you concluded?
My lord, one reply. As far as the
My lord,
present case is
but
concerned.
how many advocates will argue?
No, this is a general discussion. Your learned senior friend is only discussing on this particular point of law, not with regard to this case.
My lord, I confine to, my lord, the death of a minor where the claimants or the parents are entitled to get the filial consortium.
So if filial consortium is considered, then 1,10,000, that is there.
Yes.
Okay. If filial consortium is not there, then 80,000 goes.
80,000 goes. That is,
May
I finish my argument, Parla.
This is the thing. So 80,000 goes.
80,000 goes.
May I give reply? Just 1 or 2 lines, my lord.
Bring those decisions.
That's regarding the Nanu Ram, my lord.
No.
But as far as this present case is concerned, my lord, he has relied upon certain judgments. In Thangavell, my lord, he had been pressing on this point that the date of accident, regarding the date of accident, Thangavell, there is one judgment in his compilation he has given, my lord. There is no date mentioned when the accident took place, so it's a bad law. If he is referring to that, it's not applicable in this case. Date of accident is not written in Thangavell. My lord will kindly note it down. It's not there in Thangavell. That's the first judgment that he relied upon. Has my lord found it in his compilation, the first judgment?
Yes, the first judgment.
Yes.
My lord,
my lord, I did not disturb you. Let him not disturb me.
No, the
My lord-
decision, does the decision say?
No,
that the date
no,
of-
no.
My lord, this
No.
decision only confined to the income of a minor.
Yes. So, my lord, let him not
Maybe
disturb me when I
2000.
am submitting.
Okay,
Kindly, my lord. Kindly ask him to
Date
stop.
of accident doesn't
Oh,
matter.
once, what is he saying? My lord will kindly record date of accident doesn't matter. This is
Consider
what
the
he said.
date of decision, the ratio decedent die.
Ratio.
If
Ratio
the-
decedent.
One thing, my lord, he harped upon the
compensation.
point that the date of accident is very important. Now suddenly he says date of accident is not important. My lord will kindly note it down.
I shall consider, you see, you have relied upon decisions.
Yes, wherein date of accident is mentioned, what he said.
Now the
That
question-
2021, my lord, they'll kindly look into the this monetary aspect. It's accident of 2021. Those are of 1992. One is of 2003. So date of accident doesn't. Now he says it doesn't matter. My lord will kindly take note of this. I am thankful to him for saying this. Number two, my lord, these other judgment, Kishan Gopal, I am relying upon that one also. And the third judgment, Kumari, that is an injury case, my lord. It's not applicable in this case. 2 legs were amputated. He very, very conveniently, my lord, he decided not to point out that it's an injury case.
Anyway, if it is injury, it will not be.
Yes, I am
taken.
extremely grateful, my lord.
In Lakshmi case,
There is two distinction. You see, the day the injury,
injury
there are
case
two
is
distinctions.
different. Injuries is other non-pecuniary heads. Here, I'm only referring this.
He cannot pick and choose, my lord, like that because it's
No.
very contradictory. Whatever submissions he made.
I'm relying on this Lakshmi case because the minor girl who was aged about 12 years, like our case, and his income has been assessed, my lord, as 10,000. Even if there is no proof of evidence.
This is the 3 is with regard to injury case.
Yes.
Injury
It's
case,
not
my lord,
applicable in
he's
this
not-
case.
12 years, my lord, the girl or 12 years boy
The same view cannot be taken. You see,
is a
one
child
view is to
labor.
be taken, but an injury, another view is to be taken.
I am
Same
grateful,
view
my
cannot
lord.
be
I'm
taken.
deeply
My lord,
obliged.
injury, not injury. Injury is, my lord, confined to, my lord, the two parts. One is pecuniary and non-pecuniary. Non-pecuniary is pain and sufferings, the attendant charges, hospitals charges, every medical expenses,
yes,
everything. But in
Pecuniary
case
is
of
a monetary loss.
monetary loss, that which has been calculated by a mathematical calculation.
This last decision, this FMA 444 of 2025 by Honorable Justice Ananya Bandyopadhyay, when my ladyship was taking these cases, my lord, this is exactly
lordship has-
similar to what I have, similar to my case, my lord. My lord will kindly consider. And regarding this filial consortium, my lord, all the coordinate benches, this issue has been decided in this Honorable High Court at least. And in every court, my learned friend raises the same issue.
If you want, you can give your written notes of arguments tomorrow, and that those decisions also.
My lord. My
Okay.
lord.
My lord, your lordship, after my lord making late.
Do you want to do you want to cite those judgments?
Yes.
Those division bench judgment? Where
Yes, yes, we shall. I
So I'm keeping it tomorrow as to be
My
mentioned.
lord, my lord.
Yes, record and order.
On Monday, my lord, it
Huh?
will be because
No, I have no hearing, only citing of the decisions. Learned advocates for the parties are present, hard learned advocates. Hearing on the facts of the case is complete. However, learned advocates are granted liberty to rely upon the decisions, which is not relied today. Let this matter appear under the heading to be mentioned tomorrow.
My lord. Grateful, my lord.
Tomorrow or Monday?
Any day my lord desires.
When
Any
can you
day
bring? Tomorrow you can bring. Tomorrow.
Grateful,
my
my
lord,
lord.
the citation.
See, these MACC cases, there is no straight jacket for Mullah.
Yes.
Straight jacket.
My lord, your lordship, what is
Yes.
fallen from your lordship? No, what is fallen from
Always
your
there will be
lordship?
facts and circumstances.
Yes. My lord, your lordship
company.
says the
Milord,
just
I say-
compensation.
Milord, discussion is with the court, but Pranay Sethi, Milord, has confined that discussion. Otherwise, Milord, there is a lot of confusion.
Yes, 70% is covered.
Milord, 70 to
70%
80% is covered as far as
Oh, yeah,
quantum
that's down.
part is concerned. Milord, if we start doubting Pranay Sethi, then Milord, your lordship will not be able to pass judgment in any of those. I can say. So,
So
Pranay Sethi,
70% is covered.
yes, Milord. So, Milord, now if the query is being raised or if the question is being pointed at Pranay Sethi, then Milord, on every aspect there are stray judgments. Then we will start troubling your lordship on every single issue. Then none of the cases would be disposed of. That is why we say we keep Pranay Sethi as mother
Anyway,
judgment.
the subsequent judgments was considered.
My
by
lord,
the
subsequent judgments
was passed after considering Pranay Sethi.
my lord, meant after Pranay Sethi, it says future prospect not to be granted. It, my lord, as an officer of the court, my lord, it is, I don't think it would be prudent on my part to start troubling your lordship with one straight judgment that no, after Pranay Sethi, future prospect not been granted. My lord, in that way, if I start doing, my lord, then none of the matters would be disposed of. That is why I say your lordship will take 5 judges bench as gospel, and your lordship will kindly decide. Supreme Court in 1 or 2 state judgments can always differ. My lord, they are under 142. They can decide, my lord, for ends.
But whatever ratio decidendi the Supreme Court
Said
is down,
yes,
that has to be considered.
that has to be considered. That is why I,
even after considering Pranay Sethi,
lordship,
whatever ratio decidendi is laid down by the honorable apex.
lordship,
70% is covered.
lordship,
Whatever
lordship.
is the varying
Lordship.
factor that has
Lordship, my lord, we have to see whether it was under 140 or not. 142 or not, I mean.
Yes, yes. From the
Yes, my
judgment
lord.
itself, we can
Because
Last
Pranay
year,
Sethi, my lord, when it draws a line, my lord, when Pranay Sethi says that for funeral I give 15,000, 1-5. For loss of estate, I give 15,000. My lord, today there are judgments which have deviated from this 15,000, 15,000. There are, I can show it to your lordship, after Pranay Sethi. So, my lord, if we start troubling your lordship with those, that in one particular case, this 15 has been tweaked to 20 or 25, or for that matter, 50, then, my lord, this is a never-ending process. My lord, over in the general damages, I had given 3 categories to your lordship. What Pranay Sethi said, loss of estate, funeral, and my lord, consortium. There are a number of judgments wherein one particular honorable judge of Supreme Court adds 4th category, D. There are judgments where D plus E has been added. If I start troubling a lordship with those D and D and E, then again it becomes a never-ending process.
consider those also. Then pass my order.
yes.
If you want to
Your
settle
lordship,
out, then then I shall see what should be lordship.
What?
Solid from your lordship that the compensation would be just compensation.
Yes, ultimately, what is the ratio decidendi of every decision? That is to be followed.
Yes. Whether it is-
I'll come back.
whether it is under Article 141 or 142, I leave it to your lordship.
Yes. Okay, come tomorrow.
Lordship.
My lord, my learned friend always says more than 1,000 cases. My lord, I challenge more than the 1,000 decision. One day, my lord, he will face.
And out of 500, he has appeared, wherein consortium was limited to 40,000.
No,
he himself.
He is telling lies, my lord.
He himself, yes,
bringing
yes,
not even one of
yes.
those.
Yes.
Okay, let us see tomorrow the decisions.
9 and 10, I'm appearing on behalf of Appellant Insurance Company. পড়িনি তো কিছু।
During pendency of the claim case, মারা গেছে।
I've taken the ground of non-involvement, my lord. The accident, my lord, it took place on 26th of September 2019, and the first information report was lodged on 4th of October 2017. That is 8 days after the accident, my lord. It was lodged by the brother-in-law of the victim, and the vehicle was seized on 15th of October 2017. All these, my lord, will find from the first information report, the chart sheet, the seizure list, my lord. The first information report is at page 57 of the paper book, the first information report. I've taken other grounds as well. I'll come to that.
Future prospective line.
This is an injury case.
It's an injury case, my lord. Subsequently, the victim expired, my lord, after 2 years. So I have also taken
Pendency of the claim cases.
Yes.
In pendency of the claim case, the victim injured expired, my lord.
After 2 years.
After 2 years, yes, my lord. After 2 years, so I have also taken the ground that the legal heirs of the victim, my lord, they're only entitled for the estate of the victim.
After the injury,
My
the
lord.
victim was released and thereafter he died.
Yes, 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 yes.
Thereafter he died and her legal heir has been substituted.
So I have also taken the ground that
Anyway, that means this is a case of injury, not with regard to
yes,
case
yes,
of death.
The
yes,
case
yes,
of injury.
yes.
Anyway, let's come.
So the first information report is at page 57, my lord, wherein my lord will find
59 is the complaint.
Huh.
59 is the complaint.
Wherein my lord will find that the brother-in-law of the victim, my lord. Page 59 is the written complaint which was lodged on 11th of June 2019.
No.
Regarding this, my lord, I must humbly admit one thing. There is
8
a delay of
days.
8 days, my lord. There is one judgment against me.
Delay of 8 days.
I'll just explain it, my lord.
So that is condoned.
That has been condoned.
May I just humbly say one thing?
Yes.
This regarding this non-involvement, my lord, Honorable Supreme Court is of the view, my lord, that wherein this reason for delay, this goes against me, my lord, but still I must be candid before my lord. When this reason for delay has been properly explained in the written complaint filed by the claimants, the complainant, my lord, therein this 8 days, 2 days, 3 days, 4 days, all this should be condoned. It should not be a reason for not
Granting any
compensation.
compensation.
The judgment my learned friend has brought in this matter also, the reason has been explained in the written complaint.
And that has been decided by the tribunal below. So, ওখানে বলা আছে দেখেছি।
Since I've taken the ground of non-involvement, my lord, this is one ground because there was a delay of 8 days. I've taken that ground, my lord. My lord will deal with it as per the judgment.
Ravi versus
There's one
Bhojale.
judgment, my lord. This is the judgment.
That has been decided
It
by
was already decided by Supreme Court that
Supreme Court as well as the tribunal below also, my lord.
How much amount is awarded?
7,14,000 has been granted by
Yes.
the Supreme Court.
7,14,000.
My first ground, my lord, it goes against me. That non-involvement, it goes against me. Number one. Thereafter, my lord, I have taken the ground, my lord, regarding the claim case was since the victim expired 2 years after the accident, my lord, the legal heirs of the victim, my lord, they are only entitled to the non-pecuniary expenses or the estate of the victim, my lord, that is medical expenses and all. But the learned tribunal, my lord, awarded only considering the injury. So that ground also goes. And the third ground, my lord, is regarding the invalid driving license, my lord.
No,
I must admit that the Caesar list, the accident took place on 26th of September 2017. The Caesar list, it says that this driving license was valid till 31st of May 2017 for driving a non-transport vehicle and till 5th of September 2019 for driving a transport vehicle, and the vehicle was a truck. So this also goes. So I have argued on behalf of both of us.
My lord.
He has preferred an appeal.
I have prepared one cause objection, but that, my lord,
On future prospect.
kindly see, my lord, page 42, running page 42 of the paper book. Second paragraph, the original, my lord, kindly see, the original medical bill of rupees 22,000 is on record, but same has not been proved, my lord. Thereafter, thus, she comes to yes,
Page 42.
Page 42 of the paper book.
Yes.
And thereafter, your lordships will find comes to age group 26 to 30. The multiplier in this age group will be 17 years. Well, that is correct according to Sorla Pharma as well as Ponaseti. Here, my lord, 5,000 has been assessed the notional income. My claim was, my lord, 6,000 because he was cook as well as he was rendering service towards family, and my lord used to save money, and accident took place in the year, my lord, 2017. And here, my lord, your lordships will find, my lord, 5,000 into 12 into 17 into 70%. Here, my lord, the future prospect will be 40% that has not been added.
That she's the
That is
legal heirs are
entitled
entitled to.
That is
40%
entitled
the
to.
legal heirs are
And
entitled.
another, my lord, kindly see bottom portion, the prevailing rate of interest, my lord, just before, my lord, the ordered, just before ordered, my lord, the prevailing rate of interest of the bank is about 6%, but the case has been delayed for 5 years due to lapse on the part of the advocate of the claimant, and hence only the interest at the rate of 4% is granted on the awarded amount.
So your grievance is this:
That
you have
will be-
filed a cross objection regarding the future prospect.
regarding the future prospect as well as interest. Interest should be 6% from the date of filing till payment.
Now, if future prospect is added, how much you will be
We
entitled?
will
My lord,
make the calculation,
40%.
we will give it to my lord.
So better give a written notes of argument on Monday.
My lord, madam.
As your lord.
As your lordship desires. I'll put in also my grounds, so it
Notes
would
of
be
arguments and the calculation.
My
You
lord.
also give your own
I shall
written
put-
notes.
put
My
here.
lord.
I shall put this.
Learned advocates for the parties are present. Hard learned advocates. Let this matter appear on 10/11/2025 at the top of the list
My
for final arguments.
My lord.
Written notes of
Written
arguments
notes of
may be submitted by the learned advocate,
Including calculation.
including calculations may be submitted by the learned advocates.
My lord. Grateful. No?
It will be treated as, my lord, as well as injury case.
Yeah, no, actually it's an injury case.
Injury case. And that the calculation has to be made as
Yes,
well
yes, as per injury case.
as per injury case.
Item number 11 and 12, my lord. I'm appearing on behalf of the appellant insurance company. One Mr. Muktokesh Das is appearing, my lord. He is unable to attend court today due
Okay,
to
not this week.
My lord, request.
Not this week.
Grateful, my lord. পড়িনি কিন্তু আর আমি পারছি না প্লিজ মানডে
ওই top of the list.
আর আমার সকাল থেকে যা করেছে আমার হয়ে গেছে then next matter also my lord I just
13. Well, I am for the claimant
Yes.
respondent.
my lord will kindly pardon me and take up this matter next week my lord. I'll just get prepared in the matter.
Not this week.
I'm grateful my lord.
Item number 16 and 17.
Pass it over.
Okay.
Yeah, 16.
To 19.
This is also case, my lord. Required
16 is my appeal. 16 and 18 is my appeal. No, 16 and 19 is my appeal arising out of the self-same accident, my lord.
So, two insurance companies are there.
Same insurance company, Bajaj.
No, 16 is your appeal. Your learned friend is for the opposite party.
Yes, he has filed one cross
cross
objection.
objection for renouncement.
And 18 is his cross objection and 19 is my appeal against which he has filed the cross objection.
On a single accident, my husband wife expired, my lord. Here the claimants are, my lord, minor daughter and the parents of the victim.
My lord.
Both the cases.
May কোথায় গেল? Okay. I have taken the ground, my lord, in both the appeals. I have taken the ground of no negligence of the involved, the offending vehicle, my lord. It was a mini truck. I have taken the ground that the mini truck was not negligent at the time of accident. This is a case under section 166, wherein this rash and negligent driving is mandatorily required to be proved, my lord. So I have taken the ground that the mini truck was not negligent, not rash at the time of accident. What happened? At the time of accident, the mini truck was stationary and the victim vehicle came and dashed against the mini truck from behind. Now, the accident took place in the morning at 9 a.m., broad daylight, my lord. So it cannot be said that it was night time. There was a problem of visibility. So the speed, my lord, will kindly try to ascertain, my lord, the speed at which the vehicle of the victim was.
The victim vehicle was made party.
No.
No.
Victim vehicle was not a party.
No.
Before the trial court.
Yes, it was not a party. So at that speed at which the victim was driving his vehicle, my lord, he went and dashed against the mini truck from behind. Though the eyewitness that the mini truck was parked, that my lord will find from the evidence of the eyewitness. Then there is no dispute that the mini truck was parked. I'll come to the portion wherein tribunal has dealt with this issue, my lord. The award, my lord, starts at page 29.
Yes.
Page 29, my lord, the award starts. And the relevant portion, my lord, regarding this contributory negligence or no negligence on the contributory negligence of the victim and no negligence on the part of the mini truck, my lord, this relevant portion, my lord, it starts at
36 20 থেকে দেখো
page
36
it starts at page 24, my lord. From the above discussion, it is found that all the witnesses of the opposite party number 2 failed to discard evidence of the claimants. Thereafter, the next page, my lord.
No, page 24 of your grounds.
No, page 34 of the paper book.
Okay, page 34 of
Page
the paper.
34 of the paper book. The first paragraph, my lord, it says that Bonomali Shamonto, representing the claimant as PW1, Bonomali Shamonto is the grandfather. Representing the claimant as PW1 has deposed in this evidence, and he is the father-in-law of the deceased. His son, daughter-in-law, and 2 granddaughters met with an accident on 16th of April 2022. At the time of accident, the deceased Bornali Shamonto was traveling by their vehicle number such and such with her husband and 2 minor daughters from Kolkata towards Midnapur. The said vehicle was being driven by her husband, Shumit Shamonto. When they reached near Harina bus stand at NH6 road under Kharagpur local PS, suddenly one lorry which with excessive speed overtook the vehicle of the deceased from extreme left side of the road. The said vehicle ran over upon the soiled road for that reason suddenly. But Bonomali Shamonto is not the eyewitness in the accident. He is the claimant number 2. Now, my lord, I'll come to the evidence. This issue of this contributory negligence, it was not properly dealt with, my lord, in the award. Page 35, my lord, as I had said, paragraph
So what
21.
the vehicle of this driving vehicle proceeded with for under rash driving?
Maybe we do not, I'm not aware of the criminal court
No,
findings.
as per the evidence.
Yes.
Any this driving?
2 is the eyewitness, my lord. Page 35 is paragraph 21, my lord.
It is an admitted position that your vehicle was the stationary vehicle.
Yes.
But
Yes.
any rash and driving
When my vehicle is stationary, I cannot be rash.
No, the other vehicle.
That the exact the specific term is not there, but it can be understood. My lord will kindly see because
Whether that vehicle driver was implicated in a
no, it's a deceased victim. He was the vehicle driver. The
was
father and mother expired of this present claimant, Sanvi Shamonto. Her father and mother
Is it
expired.
a car or any public
It was a car.
Car.
It was a car. The victim was driving the car and he went and dashed against the stationary truck from behind. So he has to be he has to have contributed to the accident because the speed. My lord will kindly just visualize. I'm standing, my lord's vehicle is in front. I am driving the vehicle. When I'm driving the vehicle, I'll drive at a certain speed so that I can stop. Any vehicle can, even if for argument's sake, I take it that the mini truck was not stationary, even if for argument's sake. Even then, I may stop suddenly in front of the road because there may be, it's a village road, national highway. So many people are crossing the road, the animals are crossing, it happens so many times. My lord is well aware. So if I stop in front, my lord, the vehicle which is behind me, my lord will visualize the speed at which that vehicle was because all of them, the parents, they expired, the victim and his wife expired. And in my case, the vehicle was stationary. So the victim has definitely contributed to the negligence, to the accident, my lord. He had contributed in negligence. So my plea is that portion, that proportion of contributed in negligence, that should have been deducted before deciding the award on the part of the victim. I'll give judgments on that score. My lord will kindly come to the evidence of PW2. PW2, the evidence is at page 17 of the paper book. Has my lord found it? Page 17. PW2 is the eyewitness.
Yes, yes.
একটা প্রথমটা বলে দিই তারপর একটা বলছি paragraph 2, my lord. On 16th of April 2022 at about 9 a.m. while the vehicle bearing number such and such, that is the Grand I-10 Hyundai victim vehicle, was going from Kolkata towards Midnapur. At that time, at near Harina bus stand, one lorry with excessive speed, high speed overtook the said vehicle from the left side of the road. The lorry ran over soiled portion. For that reason, the area became invisible. And at that time, one vehicle bearing number WB335717 mini truck was standing. This is my vehicle. In the middle of the highway without signal, non-parking area, without signal, and the victim vehicle bound to dash the backside of the standing mini truck. As a result, driver deceased of the vehicle and his wife died on the spot. And their 2 daughters were taken to Midnapur Medical. So my vehicle was standing. There is no dispute regarding that. Now, whether thereafter the cross-examination is at page 19, my lord. 19. When I arrived at the place of occurrence, approximately 100 persons already assembled there. So he is not exactly the eyewitness, because already there were 100 persons who had assembled there. He had not seen the accident, but he said that this is, so it's hearsay. I saw the offending vehicle at the place of occurrence, mini truck, my vehicle. I cannot state the color of the offending vehicle, number such and such is the vehicle of the deceased. Offending vehicle color he cannot say. He was not an eyewitness. It is all hearsay. I did not know the deceased. Very fine. I accompanied the deceased to the hospital. That is also the. So this is the important. These 2 lines are important, my lord, as far as witnessing the accident is concerned by PW2. Thereafter, my lord, PW3 is another eyewitness, my lord. That is at the next page, my lord. Page 20 is the affidavit, the examination in chief. And page 22 is the cross-examination. PW3.
Yes.
Page 22 is the cross-examination. I have not received any summons from the court. I, on being asked by the claimant, have come to depose today. I was at the place of occurrence prior to the accident. My house is 30-35 kilometers far from the place of occurrence. At the relevant time, I was with my friend, was coming back from Kharagpur, coming back towards Kharagpur from Kolaghat with car number such and such. At the time of accident, there was a huge mist of dust at the place of occurrence. I pause here for a moment. When there is a huge mist of dust, my lord, the normal reaction would be to definitely slow down the vehicle, victim vehicle. But this mist of dust, my lord, this also could not make the victim slow down his vehicle. And he went and dashed against the backside of the admittedly stationary truck. That is my mini truck. My lord will visualize once.
Any of the passengers of the victim vehicle survived?
No. The passengers of the victim vehicle, there were 4 passengers. 3 passed away,
Yes.
including the victim driver who was driving his vehicle.
3 passed away.
And 1 survived. One survived.
So was he examined by any?
That's a minor girl.
That is minor girl.
So this is the evidence of PW2 and PW3. And in any event, 100 people were already there. So PW2's evidence cannot be relied upon. Even if we go with, even if we rely with the evidence of PW3, my lord, then also when there is a mist of dust, the normal reaction is to, as I said, to slow down the vehicle so that the dust clears out and thereafter drive it. Or slow down and drive. It's unfortunate that at that speed, the victim vehicle was driving and he dashed against my mini truck. Now, my lord will kindly come to the chart sheet. It's at page 57. Page 57, 57. Serial number 11, details of properties, my lord will see. 11.2. One Hyundai i10 vehicle having registration number such and such, front portion badly damaged. That will only happen because of that impact of rash and negligent driving on the part of the victim himself. And the victim expired. So, my lord, the driver of the of my mini truck, my lord, the charge sheet was filed against the driver of my mini truck. The page 61 is the relevant page. It starts at page 60, brief facts of the case, serial number 17.
During investigation.
Yeah.
Page 61.
Page 61, 61.
Yes.
And in that, my lord.
Yes, both the vehicles were seized.
Yes, I'll just page 61. This first paragraph, my lord. Yes, both the vehicles were seized, my lord. Thereafter, during the investigation, that observation of the investigating officer is there. And the findings are at page 63, my lord. So I consulted with my superiors and discussed about the merits of the case. As per their kind direction, I submitted charge sheet against Madhav Modi, who is the driver of my mini truck. So this is as far as the contributory negligence on the part of the victim is concerned.
It's 62 bottom portion, your lordship will find during investigation as well as the statement of the witnesses. It's 62 bottom portion, my lord. Conclusion part of.
Yes, he that is this heavy dust was blowing, reduced. All this I've already said, my lord.
Yes, my lord.
So regarding
that stationary driver's vehicle was implicated.
Yes, that is my vehicle, mini truck.
Regarding this accident, what is the cause found in as per investigation other than mechanical failure?
Illegal parking.
So this thing after inspection of the above vehicle in mechanical point, in my opinion, the above incident occurred other than mechanical failure.
Where my lord is reading from page
61 last.
61. Other than mechanical failure. Thereafter, during investigation as well as the statement, last paragraph of the witness and circumstantial evidence, it was learned by me that on 16th of April 2022 at about 8 hours, the victim having registration number such and such coming from Medinipur near Harina bus stand under Rato, a truck tried to overtake the victim vehicle. This truck has not been made a party, nor seized, nor nothing. The entire fault is of this truck. As a overtake the victim vehicle at a high speed, and on that time the said truck fell off the pitch road. This fell off, it's only here, it's nowhere. The eyewitnesses, they never say this. As a result, heavy dust blowing and reduced forward visibility. At that time, driver of the victim car, Hato, did not realize that we do not know, because the victim victim had already expired. Then the victim's car went behind the truck and hit it.
The incident happened
Because of the
offending
incident happened
vehicle.
because the driver of the offending vehicle having registration number such and such, this is my mini truck, parked the vehicle illegally on the road. That also we do not know because there was a mist of dust. This statement is kind of pick and
You
choose,
see,
my lord.
in the absence of the driver of the vehicle,
Yes,
who may have contributed to this accident, in his absence, when he is dead, when in the absence of the owner of that vehicle, on what basis the court will come to the conclusion regarding contributory negligence?
I'll give judgments on
That
that.
is the basis.
Yes, I'm
When
great.
the person is dead,
Yes,
some other driver is dead.
it's on
That is to be considered.
It's on the basis of res ipsa loquitur, my lord. The incident speaks for itself. When I'm at the front, I'm going. It is very difficult for me to ascertain the speed. When I'm driving, it is very difficult for me to ascertain the speed at which the vehicle which is behind me, which is coming. I'm driving, I may stop. I'm applying brake. When the vehicle which is behind me, if that vehicle also applies brake, then the speed slows down.
That is the thing.
I'll give judgments on this.
Contributory negligence.
Yes, I'll give judgments on that.
Charge sheet has been given, my lord, against the driver of the offending vehicle as
No,
PW.
any evidence?
OPW
Any evidence with regard to this, the driving from your side? Any witnesses examined?
Yes, the offending.
Yes, ma'am. From my side.
Of the driver of the offending vehicle.
Yes, I have another matter at 1:10.
My lord,
Yes,
my
yes.
lord.
No,
Maybe come back
Kindly fix
tomorrow.
it. Kindly fix it any of the next week. My lord,
Yes,
argument
record
I
an
come.
order. Learned advocates for the parties are present. Hard learned advocates. Let this matter appear for further hearing on 10/11/2025.
Yes.
Within first 10 matters.
And my lord, we shall file written argument also because of the fact, my lord, learned tribunal will consider the case also, the Momta and others case.
Yes, come with the written note
My
of
lord.
arguments on the next day.
Yes.
And the decisions.
Yes.
Hey, call,
My lord will be calling on this list from 2 p.m.
Wherever I have stopped, that will continue next.
My lord.
At 2 o'clock.
At 2 o'clock.
Yes.
My
আচ্ছা এই জলপাইগুড়ি ম্যাটারটা কল করে দিই
grateful, my lord. No, আমার আছে ভাই, আমার ছুটি নেই।
আমাকে থাকতে হবে যে আমাদের
কিসের কালেকশন হ্যাঁ এটা কি মেনশনিং করেছিল মেনশনিং হয়নি কি ইয়ারটা কালেকশন শুধু এটাই কালেকশন yes yes record an order this matter is put up for necessary correction in the cause title of the case it is marked as CRM M 306 of 2024 and it should be rectified and corrected as CRM M 306 of 2025. Stop. The contents of the order remain unaltered. আচ্ছা এইটার উপরে তো এটা তো কমিউনিকেটও হয়ে গেছে আর কি যাই হোক তাহলে এটাও তো যা না না এটা তো ঠিকই আছে এটা তো এখানে কারেকশন হয়ে গেল পরবর্তীকালে ওই একবার ওরকম হয়েছিল 2025 দেখা গেল হিয়ারিং কনক্লুডে 2024 জাজমেন্ট এটা একটা হয়েছিল ওরকম এটা রেকটিফাইড হয়ে গেল না এটা আবার বলা হয়েছে যে let a copy of this order be sent to the হ্যাঁ 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 তাহলে কি কালেকশনটাও পাঠানো হবে হ্যাঁ রেজিস্ট্রার কি ওটা কি কমিউনিকেট করবে কিনা সেটা হ্যাঁ ডিপার্টমেন্ট রেজিস্ট্রি তাহলে কালেকশনটা ঠিক হবে আর কি
Side item number 21.
Not today.
22.
22 is insurance appeal. Mandarin is appealing on behalf of the claimant.
Yes.
Pursuant to,
So it is ready for hearing.
No,
my lord, pursuant to the earlier direction of this honorable court, my lord, insurance company has deposited the compensation amount. The lordship will kindly today make the stay absolute and pass direction for filing of paper books.
This scan application is not appearing. Item 21.
22.
22, your lordship.
22. Where is the scan application? Oh, right. Can 1 is appearing. Yes. Where is that receipt?
Not I'm sorry, I don't have the photocopy. Not, I'm just showing the original here. Your lordship will kindly take a record and then.
Anyway. Yes. Yes. Record an order. Learned advocates for the parties are present. As the appellant insurance company has deposited the awarded sum in terms of order dated 23/4/2025, the judgment and order passed by the learned additional district judge, 4th Court, Purbo Bardhaman, in MSC case number 93 of 2016 shall remain stayed till disposal of the appeal. Yes, you will file your paper books. How long? When you will file your paper books?
4 weeks, my lord.
Yes?
4 weeks, my lord.
Yes. Learned advocate for the respondent prays for time to file the paper books. Thus, the time to file the paper books is granted till 3/12/2025. Let this matter appear on 8/12/2025.
Grateful to my lord. Thank you.
Number 24.
24 is insurance appeal. My lord, pursuant to the direction passed by this honorable court, I have secured the awarded sum before my lord's court. My lord, I am filing my affidavit of service before your lordship. Lord, in this case also, I spring your lordship will kindly make this stay absolute and my lord service to the department. My lord.
Yes, record an order. Learned advocate for the appellant is present. Yes, what is that receipt? Yes, as the appellant insurance company has deposited the awarded sum in terms of order dated 13/6/2025, the judgment and order passed by the learned additional district judge, Fast Track 3rd Court, Sodor, Paschim Medinipur, in MSC case number judgment and order dated 19th December 2024. 19th December 2024, passed by the learned additional district judge, Fast Track 3rd Court, Sodor, Paschim Medinipur, in MSC case number 467 of 2018 shall remain stayed till disposal of the appeal. The appellant shall take steps to cause service of notice upon the respondents to the department. Let this matter appear on 17/12/2025. Trial court records be called for. 17/12.
Twenty-five.
25, I'm appearing on behalf of the appellant insurance company. This is the copy of the challan. I've already deposited the entire awarded sum before my lord's court. My learned friend is appearing on behalf of the claimants.
Trial court records have come.
We have the entire certified copy of the entire trial court records. I'll
And the
prepare the
depositions,
paper.
everything.
Everything, my lord. I'll
Just
prepare
record
the
an
paper.
order. Learned advocates for the parties are present. As the appellant insurance company has deposited the awarded sum in terms of order dated 19/5/2025, the judgment and order passed by the learned additional district judge and special court Alipur South 24 Parganas, additional district judge come special court, EC Act. Actually, the judgment and order dated 8/1/2025 passed by learned judge special court within bracket EC Act come EC East of C Act come additional district judge Alipur South 24 Parganas in MSC case number 488 of 2011 shall remain stayed till disposal of this appeal. Learned advocate for the respondent press for time to submit the informal paper books. The time to submit the informal paper books is granted till 28/11/2025. Let this matter appear for hearing on 2/12/2025.
My lord. এটা ফাইলে দেখে নিতে পারি আমার ফটোকপি হ্যাঁ 26, I'm appearing on behalf of the appellant insurance company. In this case also, I've deposited the entire awarded sum and I've served, but I shall take steps.
Respondent has entered appearance.
I shall take steps. I shall put in Talavana and return of notice forms.
Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the awarded sum in terms of order dated 19/5/2025, the judgment and order dated 13/1/2025 passed by learned additional district judge 6th court Paschim Medinipur in MSC case number 71 of 2022 shall remain stayed till disposal of the appeal. Stop. The appellant shall take steps to cause service of notice upon the respondents through the department. Let this matter appear on 17/12/2025.
Grateful, my lord.
আমিও তো তাই ভাবছিলাম।
27.
Below the 27 is insurer's appeal. Pursuant to the interim stay order, I have deposited the compensation amount. May I file, my lord, this deposit slip? I'm not affidavit to service be kept with the request, my lord. Your lordship will kindly make this stay absolute. And my lord, let the service be again, my lord, done through department.
Yes.
Recorder, you can-
Learned advocate for the appellant is present. As the appellant insurance company has deposited the awarded sum in compliance of order dated 25/7/2025, the judgment and order passed in judgment and order dated 15 January 2025, passed by learned additional district judge, first court, Shuri, Birbhum, in MSC case number 169 of 2011, shall remain stayed till disposal of this appeal or till further orders, whichever is earlier. The appellant shall take steps to cause service of notice upon the opposite respondents through the department. Let this matter appear on 12/12/2025.
12th of December.
12th of December.
Lord, in all these cases where my lord is making the stay absolute, stay application is disposed of.
Yes. Stay application stands disposed. All cases stay application stands disposed.
My lord.
Can dispose of.
Can disposed.
যতক্ষণে stay absolute হচ্ছে সবকটা থেকে
চব্বিশ, 26, 27, ঠিক আছে? হয়েছে না? হ্যাঁ, 25, 26, 27, ঠিক আছে? 22 তাই?
হ্যাঁ, 22 stay absolute.
And about 28.
Lord, the 28 is also insurance company's appeal. Lord, pursuant to the stay order passed by the Honorable Court, Lord, I have deposited the entire compensation amount. Lord, my learned friend is appearing on behalf of the claimant. Lord, my learned friend has filed a separate appeal against the self-same award. Lord,
it is appearing in the list.
Lord, it is not appearing, my lord. Lordship will kindly make my stay absolute, and your lordship will kindly, my lord, direct on the next day. Let this appeal, separate appeal of my learned friend should also appear along with my appeal, my lord. And lordship will also file, my lord. Your lordship will kindly
file paper books.
But he will file paper book, and in the paper book, my lord, this appeals document should also be incorporated.
Yes, record and order. Learned advocates for the parties are present. As the appellant insurance company has deposited the awarded sum in compliance of the order dated 25/7/2025, the judgment and order dated 26 June 2024, passed by the learned additional district judge, third court, Balurghat, in MSC case number 6 of 2014, be stayed till disposal of this appeal. Let the appeal FMA, what is the number?
Lord, this is FMAT MV 554 of 2024.
554 of 2024.
Lordship.
Appear along with this appeal,
my lord,
for hearing.
For hearing, lordship.
Learned advocate for the respondent prays time to file the informal paper books. The time to file the informal paper books is granted till 28/11.
20 December, first week of December.
Okay.
554
3/12/2025. 3/12/2025.
My lord.
Let this matter appear for hearing on 8/12/2025.
8/12/2020. Oh, bless you. Beautiful to
Number 29.
My lord, on 25th July 2025, my lord, interim order was passed, my lord. And in compliance with that order, my lord, I have secured the entire awarded sum together with interest before this honorable court. My husband is
I am
appearing
appearing, my
for
lord.
the respondent claimants. Kindly allow us stay application by absolute.
Yes, record an order. Learned advocates for the parties are present. As the appellant insurance company has deposited the awarded sum in compliance of the order dated 25/7/2025, the judgment and order passed by the learned additional district judge, second fast track court, Bahrampur in Murshidabad. The judgment and order dated 20th of July, 20th July 2024, passed by learned additional district judge, second fast track court, Barhampur, Murshidabad in MSC case number 276 of 2014 shall remain stayed till disposal of the appeal. Learned advocate for the respondent prays for time to file paper books. Such time is granted till 3/12/2025. Let this matter appear on 8/12/2025.
The application disposed of.
Yes, the application stands disposed.
Number 32.
32, who is appearing? Okay, not this week.
This week. Hearing claim cases 33.
Let,
33, my lord, I am appearing for the appellant insurance company. My lord, the court has not been tagged, my lord. Let it be fixed on Monday, then the court filed by the respondent has not been tagged.
Okay, so there is any another appeal, counter
cross
objection.
objection on the last day, my lord has recorded it in the order. It has to be tagged.
No, when it is due to appear.
It was supposed to appear today.
Yes. So I make it not today or not this week.
My lord, kindly fix it upon Monday, my lord.
Okay, just not this week. Yes, record an order. হ্যাঁ ওটাকে ট্যাগ করে দেবেন তাহলে ওইটা ও আসেনি রেকর্ডটা Okay, just not this week.
I'm grateful, my lord. My lord, another submission, my lord, on 4th last day, working day, my lord. A hearing was done on item number 22 and 20 with 23 and pay and recover. I was for the appellant insurance company, my lord. Or the judgments I have sent to my clerk, my lord. Kindly ask your court officer to accept those judgments.
Okay. Okay.
I'm grateful, my lord. I'm grateful.
My chamber.
I'm grateful.
কালকে যে কটা থাকবে সেগুলো দিয়ে দেবেন আর কি পাঠার যেগুলো হ্যাঁ ওগুলো
দেবে কিন্তু ওই প্রথম ভুলে যাবো তো আমাদের নামগুলো না ছবি